So are we going to get the truth out today, guys?
Well, everything that was said in court.
Yeah, that's what we're
Everything that was said in court?
Yeah.
Oh, hey, this is new. I like this. You know, if everything that was said in court the last time came out, you'd have a lot of Canadians questioning the validity of the Crown's theory in bacterial meningitis when Dr. Annie Savageau testified that there was no scientific backing whatsoever for bacterial meningitis. So this is awesome if you guys are going to actually get everything that was said in court out. But I've yet to see it, so I'm excited.
So the result today, are you surprised at how it went?
You know, to be honest with you, I'm actually not overly surprised, unfortunately. The issues of procedure were definitely coming up, and as a lay person, as a self-represented litigant, you know, I'm not that understanding of the ways of court, and so if it was basically turfed on procedure, then I'm not that surprised.
Are you encouraged that the judge didn't tear apart your arguments on merit? He was very clear on that it didn't have anything to do with merit.
That's correct. He did not go into the weight of the evidence that was brought forward. That was not his place. He would have been pretty hard pressed, I think, to try to tear it apart. The prima facie evidence there that needs to go before the courts properly is pretty substantive. The unfortunate thing is we've looked into it. We don't have $500,000 to begin this process, because if it was just one party that was involved in deceptive tactics, then yes, it would be a cheap lawsuit. But when we went and actually discussed this with a civil lawyer, as soon as you implicate one party and they have connections to another party, you got to bring them in. And by the time that we were done looking at everything, we didn't have $500,000 when we were already busy using all of our resources to fund this, what we're going to call malicious prosecution.
And as you move forward now, not getting this award, how do you plan on being able to fund the next trial?
But by the grace of God, go I by. We don't know. We will figure it out, though. We'll be provided, I'm sure.
Would that include potentially pursuing this in civil court?
Well, you know, if we had the money, we would have already been before the civil courts to have all of these facts tried, all of the evidence brought forward and substantiated. We don't have the money for that. We don't have the money to fund these criminal proceedings to keep myself and my wife out of jail. So there's no way that we can then incite action in the civil courts at the same time. And unfortunately, these issues have a statute of limitations connected to them, and so we may never get the opportunity. It's possible we may never get the opportunity to have this evidence tried before a court of competent jurisdiction and have the Crown and the RCMP and Alberta Health Services held properly liable for all of the issues that they have created through colluding together.
What were you hoping to appeal when you asked the judge at the end?
I was hoping to appeal the application that we just made, bring it to a higher court. This needs to get put before the Supreme Court of Canada. They need to become aware of what is taking place in the Alberta judiciary.
Now, when you were, what were you actually, were you hoping for just a stay of proceedings until you got legal representation, or were you hoping that they would dismiss the charges?
We were hoping for a stay of proceedings until we got legal representation. You see, it's kind of a bittersweet. It would sure be nice to have this case turfed like it should be, but on the flip side, it would sure be nice to have all the evidence tried in the courts and hopefully the media reporting properly on what's taking place within the court system so that the Canadian public are brought to attention as to what is taking place in collusion with the RCMP and Alberta Health Services and the Crown.
You'd said before you were looking forward to going through the trial again to get the truth out there. Do you still feel that way? It'd
sure be nice. If the courts are going to be amenable to having the truth come out. You see, there was the argument that kept on going back and forth up there in regard to an inquisition versus getting the truth out. And it appears that there's a fine line between getting the truth out and crossing the boundary of it, making it an inquisition. And this needs to be fully examined to get the truth out. There is a lot of errors, a lot of issues, a lot of deception. I mean, we've got falsified evidence, we've got destroyed evidence that we've been putting in requests for, and we haven't got anything back. They say that it's not existent. If it is in existence, we want it. If it's not in existence, this should not be before the courts. And so if we can get it so that we can be before the courts with a proper trial, and have this information come out. That would be pleasing. As heart-wrenching as it's going to be for myself and my wife, it would sure be nice to have the truth come out.
The back and forth that kind of played out between you and the judge through your arguments, based on your correspondence with him in the past, did you expect that that was how it's going to go today, or do you think you were going to be able to present everything kind of unfiltered before he responded?
I was anticipating that it was going to be a lot more fluid in regard to my laying out the arguments. I didn't anticipate that it would be a back and forth, but it was what it was, and I was still able to get, I think, just about everything out that I was looking to get out, to get in front of the courts on the record that he could then weigh appropriately. And it's unfortunate that it came down really to procedural issues.
And I guess just how much work went into preparing that?
Let's just say that I haven't been working a regular job for about 2 months now, and I've had to cancel numerous presentations that I was going to be doing in the Vancouver area because I haven't had the time to engage in anything other than preparing for these proceedings. And it's not just me. I've fortunately been receiving some voluntary help as well as some others who have been able to provide their assistance.
Going back to that decision, and he says that he dismissed it, but not based on the merit of it. I know you mentioned that, but he said that it's just maybe this is not the venue for this. I mean, just your thoughts on all of that.
Yeah, you know, R versus Craw, the case law that we cited, took place within a criminal setting, not a civil setting. And so that's what we were largely hanging our hat on, is that these matters, though in essence kind of civil, can take place and be remedied within the criminal setting, within the criminal proceedings. And so that's what we were looking for. In fact, it would only make sense that when we're talking about ensuring a fair trial in criminal proceedings and needing the money to do so, that the courts would then examine the relevance of why costs should be awarded for a previous trial to ensure a fair trial moving forward. So I find it interesting that it was dismissed based on the procedural issues that my understanding is he was basically saying this is supposed to be before a civil court, not a criminal court. That's the way I interpret it, and it's just really unfortunate that that they weren't willing to examine that and to use what we feel is their proper jurisdiction to award costs for past issues, especially in regard to the errors in law made on behalf of a judge that ultimately injure the accused. And that's where we're sitting today, is we've been injured not because of our own doing, but because of an error in law from the first trial judge, and we're having to foot the bill for it. That's fundamentally wrong.
So what do you see are your options now moving forward to February?
I don't know. I don't know what the options are moving forward into February. We may have to continue to self-represent. We're gonna explore a lot of options that need to be explored.
Why not legal aid?
Legal aid, first of all, when we examined it, was extremely deficient. I even consulted with 2 different lawyers who have experience with legal aid on even simpler cases, and they've reported that it falls short of providing all of the necessities to ensure that a fair trial takes place. So with a case like ours where it's extremely complex, when I was looking at the breakdown of what lawyers can bill out, there's no way that legal aid would provide the proper remedy. That's where the Fisher application comes in to extend that, but it still wouldn't combat the fact that now the Crown has our defense file that the RCMP released to them, and our position still is that litigation privilege was breached when we brought that defense file to the RCMP to incite an investigation against the Crown, against the OCME's office, and against Alberta Health Service employees. And rather than inciting an investigation, they just took it and just fed it to the Crown. The Crown now has their defense file. So I think we're far past ever being able to get a fair trial, regardless of even the remedy that's provided. But definitely a Robotham or legal aid and a Fisher application would not ensure a fair trial in this instance. It would not provide the remedy.
I'm sorry, so I understand.